Hi, it's Mike DelSignore, Massachusetts OUI lawyer. In today's video, I want to talk about what happens if you're charged with OUI and the case is going to be heard in the Springfield District Court. Now, you might have gotten an OUI charge leaving the casino in Springfield, visiting the Basketball Hall of Fame. There's many highways that are within the jurisdiction of the Springfield District Court. So it's a very busy court. So keep in mind, an arrest, it's not a conviction. Doesn't mean the case is over. It means you were charged. It does mean you have to go to court, and you probably have to go to court a few times, but you might be found not guilty. So keep that in mind. These are difficult cases to prove. The government's got to prove beyond a reasonable doubt, and I'll explain what that means. That means, let's say you refused a breath test. They got to prove that not only that you so-called failed field sobriety test, but that was related to alcohol. They got to show bad driving. They got to show that your alertness, your ability to respond promptly was affected by alcohol. So how do we win these cases? We, one, try to minimize claims of erratic driving by showing that any defect they found in your driving could be caused by other factors like being tired, maybe other drivers on the road, where somebody was tailgating you. So there's generally more to the story than the police know. So we want to minimize that. There's some cases where we have some bad driving and we want to shift our focus to sometimes segment out the driving. So example, somebody might be driving erratically and then the police put the blue lights on and they pull over fine. So it shows us two parts of the driving. One, when the lights went on, two, before the lights went on. So potentially, you might not have been paying attention, but then when the lights went on, you're focused, you're alert. And that shows someone who has good mental ability, and it doesn't eliminate the fact that maybe you crossed the lanes, went into over the fog line or things like that, but it neutralizes it somewhat. So it helps. So when you do a trial, sometimes the evidence isn't going to completely contradict part of the government's case, but it might neutralize it a little bit. So what we'll need to do in a case where we have some bad driving is we want to focus on other parts of the case. There's generally three parts of the case: the driving, the initial interaction, and then the field sobriety test, and if you want to call the booking a fourth part of the case as well. So with the field sobriety test, I generally feel like that's a good part to show reasonable doubt, because many people do a lot of things right on these field tests. Often the reports are very vague about how you even did on the test. So if there's vagueness in the report, if it's unclear, most officers will admit you did the thing well. Let me give an example. The 9-step walk and turn, a lot of reports say the person went out 9, back 9, unsteady, missed heel to toe. Great report in my view, because we don't know how many steps you missed. We don't know when you stepped offline. It means there's some things you clearly did right. You counted the number of steps. You didn't stop while walking. You maintained balance during the instruction phase and started on time. Those are all things the officer didn't say you did wrong. So if they don't say anything negative in the report, it means you did it right. So on my website, you'll see examples of this, of what we look for in a police report. So there's the stop, there's the initial driving, the stop sequence, and then the officer comes up to the car, asks for your license, registration, things like that, and makes an observation, generally odor of alcohol, bloodshot eyes, slurred speech, asks you to get out of the car. So getting out of the car is another one of those things where if there's no mention of you stumbling, using the car for balance, shows that you did those things well. The license and registration, if you didn't fumble, bobble for it, something you did well. So we add up all these things and we say, geez, they got the license, registration, pulled over fine, got out of the car without using it for balance. All these things are tests that they don't tell you about that contradict the opinion you're impaired. At booking, generally people score a lot of points at booking because you're polite, cooperative. Most people are polite, cooperative. They do fingerprints, they have you stand, and a lot of times the reports don't say anything about the observations in booking, which is significant because you're only on the side of the road for generally 10 to 15 minutes. The drive to the barracks is short, so the booking is like 45 minutes. So that's the greatest opportunity to make observations. So I always find there are key facts in booking that bring out reasonable doubt. So the key facts in the field tests that bring out reasonable doubt, show what you did right. Don't just accept the officer's version of what happened. So when you're reading your report, after the arrest, keep that in mind, that what the report says isn't the complete story. Your lawyer is going to be able to fill in the rest of the details to advocate for your defense, that there's reasonable doubt and that you should be found not guilty. So Generally speaking, on a first offense, is not a huge downside to fighting these cases. If you found guilty, you'll get a guilty, whereas you'll get the same penalties typically as if you took a plea. A plea would be continuance without a finding. So one's technically a conviction and one's not a conviction, basically. So guilty is a conviction, quaff, technically not a conviction, but they're very similar in the sense they're going to count as a first OUI offense. So consider fighting these cases. Not a huge difference. You can seal a quaff or a guilty after 3 years, so this isn't going to be on your record forever. The toughest part about an OUI first offense is the license loss. If you refuse, it's a 6-month license loss. You're probably going to serve most of that license loss. Don't appeal it. The registry is taking additional suspensions out for people who appeal. If you took a breathalyzer, 30 days, you get your full license back, and then you'll have to try to get the breath test excluded, find a way to get it knocked out of evidence. Otherwise, you'll potentially have another license loss down the road. So this is my passion. I help people every day. This week, for example, I did 2 trials, 2 motions, right in the thick of things. I'm questioning officers, cross-examining them. This is my life every day, is helping people get back on the road after an OUI offense. And I'd be happy to help you. Call, text anytime, 781-686-5924. Mike DelSignore here to help. My passion is helping people get their life back after an OUI arrest.